This is attorney Stephen Spano with a legal and financial minute, or two. Many married couples own a car in their name alone and not jointly with their spouse. While there are many valid reasons for owning a car solely in the name of one spouse, absent some very specific reasons, both spouses should be listed as co-owners of each car. So what happens to the car that is owned only by one spouse when that spouse passes away? Well, the answer depends on who you ask. Many surviving spouses are told, often by an attorney, that they have to go through the probate process. Unfortunately for them, that advice is almost always wrong. The only time it's necessary for a surviving spouse to go through probate for a car is when the car is owned only in the name of the deceased spouse and the deceased spouse had a will that left the car to someone other than the surviving spouse. Otherwise, no probate. Well, that sounds a little complicated, but the reality is, unless there's a will that leaves the car to somebody else, no probate for the surviving spouse. The surviving spouse can easily and completely avoid probate for a car owned solely in the name of the deceased spouse by completing some relatively simple documents, including an affidavit of the surviving spouse and submitting those documents to the Registry of Motor Vehicles. The car can then be transferred to the spouse or sold to a third party. You do not even need an attorney. If there's a substantial loan on the car and the surviving spouse doesn't want the car, then there are other options available that can also avoid probate. Remember, with expert planning from a specialized attorney, you can avoid probate and create a cohesive plan to carry out your wishes. If you have any questions on this important topic, call or text Spano and Dwicky at 781-231-7800 or email help@spanodwicky.com.